Hi, I'm Katie Spaduro, and I'm here with our Ask an HR Pro series, where we answer your questions that you send in to us, or just questions that we are hearing from our clientele. Can I terminate my employee for anything? Well, this is a tricky question, and we hear it a lot. So technically, yes. That is if you are in an at-will state. At-will employment means that an employer can terminate an employee for any reason without warning. However, even if you are in an at-will state, you probably do not want to terminate an employee without warning. At-will employment is not a blank check for you to terminate any employee you do not like. If you want to cover your bases, avoid unemployment, and most of all, avoid a lawsuit, there are certain steps you should follow before terminating an employee. We typically work through a checklist of sorts before terminating an employee, and you can find that on our website. First, one of the first things you want to check for is a job description. Do you have a current job description for the employee's position? Job descriptions are an important tool for disciplining employees because they spell out exactly what the job entails. If you do not have a current job description for all positions at your company, you will want to get those created as soon as possible. Secondly, do you have documentation of the issue or the behavior leading to the termination? If you have proof of the inappropriate behavior, that is the best situation. For example, proof of inappropriate behavior could be multiple witness statements, a documented investigation, badge times showing late arrivals, attendance records, emails or customers' complaints, or video footage of an offense. Ideally, you should have proof of some sort to prove your case. Your state's unemployment office, as well as the court systems, often put the burden of proof on you, the employer, to prove that an incident happened or didn't happen. Next, has the employee been warned about this issue or behavior before? Typically, you want to warn and discipline an employee for any issues prior to the termination. These warnings or corrective actions should be documented. If you can prove that an employee has been warned on multiple occasions not to do something, it is an easier case to win a lawsuit or an unemployment case. Super important. If the employee violated a specific policy, do you have a written version of this policy in your company handbook? This is huge. If you do, did the employee sign a receipt of handbook acknowledgement form? This is a super important document that is typically stored in an employee's personnel file. This document proves that an employee saw, read, and understands your handbook and policies it contains. Your handbook is not as effective if you do not also have that signed acknowledgement form. They can say they never saw it. One of the most important things to consider before terminating an employee is protected status. This means analyzing whether or not the employee belongs to a protected class. This could be a protected class that is covered by the Civil Rights Act of 1964, for instance. Or it could be a protected class from within the Americans with Disabilities Act, the ADA. Similar to protected class, you want to make sure that this termination will not only you don't want it to look like retaliation for complaining about harassment, filing a workers' comp claim, reporting a workplace injury, or taking time off for a serious health condition. These are all complicated issues and ones that your HR professional will be able to help you review, and it's super important to run it by an HR pro. To be clear, none of these reasons would mean that you cannot terminate an employee for violating a policy or otherwise poor behavior or poor performance. However, it is definitely important to be aware of other complicating situations. Terminating an employee is a situation in which you want to minimize your risk and exposure as much as possible. In the case of a protected class, you would want to make absolutely sure that all of your documentation is in place and that you have solid proof for making your business decision. An extra step to protect yourself would be to fill the position with a person from the same protected class. In cases of FMLA, workplace injuries, or other formal complaints, your HR professional will just want to work through those on a case-by-case basis alongside you. There's so many things to know. We know this is a lot to think about, and luckily for business owners everywhere and small companies alike, companies like Cyber exist, and we specialize in getting your business to the next level without you having to hire HR in-house. Remember to communicate with your employees and have your processes in place, and let an HR professional help you along. Outsourced HR support gives companies of all sizes a leg up and allows small business owners the ability to continue to make decisions legally and with the support of an HR team. It has also been shown that you may even sleep better at night knowing that your bases are covered. Isn't that the goal? Thanks for checking out our blog. That's all we have today. Please let us know if you have any HR questions that you want to have answered. We really do pull from our clientele and those that follow us, and we answer your questions. So reach out to us, and we will speak with you soon.